pass the
Court in session, Honorable Judge Lacy, clerk presiding.
Thank you. Please be seated.
I may ask if we allowed to.
Good morning. I'm Judge Clark, and we have several matters on the docket this morning. The inmates are in the building, but court security is just trying to get them where they need to go. So Mr. Rushmeyer should be here momentarily. And let me go ahead and get appearances on the record on State v. Rushmeyer 2014 CF 2354 from the state.
From the state, Matt Casey with the State Attorney's Office.
Your Honor, Steve Medina with the Public Defender's Office appointed for purposes of this evidentiary hearing on defined matters by the court. Thank you.
Thank you. And we're just waiting on Mr. Rushmeyer.
It looks like he's going to get them right now.
Okay, great, thank you.
And Your Honor, may I?
Yes.
Just because we're doing preliminary matters, I did discuss with Mr. Casey and the witnesses that I would be invoking the rule with respect to Mr. Rushmeyer's whenever that begins. Thank you.
Okay, thank you.
Your Honor, because he's just being made available, can I have a moment to whisper with him?
Sure.
Okay, thank you.
All right, and Mr. Rushmeyer is present. Sir, if you'll just state your name for me, please. Thank you, sir. So, Mr. Medina, would you like me to invoke the rule now?
Yes, Your Honor, please.
All right, I'm not sure who is here to testify as a witness. Is it?
Yes, Your Honor, both parties have subpoenaed Mr. Shaw, and then the defendant also subpoenaed the father and mother of Mr. Rushmeyer, who are aware they're going to need to step out as well.
Okay.
Rick Rushmeyer and Deborah Rushmeyer. The other three family members can stay, they're not witnesses.
Okay, so those of you who are called as witnesses, something called the rule of sequestration has been invoked. What that means is the witnesses have to step out of the courtroom until they're called in to testify. While you are waiting to testify, please do not discuss your testimony with anyone except one of the lawyers. Please do not confer with anyone who is in the courtroom or watching the proceedings online about what's going on. Please do not watch the proceedings online while you're waiting to testify. So what that means is you can't receive communications from people in the courtroom telling you what's happening. You can't watch what's happening, and you can't discuss your testimony with anyone except one of the lawyers. Does everybody understand that? Okay, so at this time, I'll ask the witnesses to please step out until you're called in to testify.
You take it first.
I'm probably gonna have Mr. Rushmeyer testify first.
And those of you who are in the courtroom, please do not communicate with the witnesses. Thank you.
Your Honor, I was just inquiring, Mr. Casey, one of our witnesses has a serious health issue, so if there were any reason we needed to do his testimony first, we could do that, but I'm not aware of anything.
And that's correct, Your Honor. I've spoken to Mr. Shaw, and he hasn't indicated anything to me. So I think for now, I'm fine. If we take a break later, I certainly can inquire.
Okay. So I know a potential issue was raised yesterday. Mr. Medina, you alerted everyone by email about a potential need for a continuance.
Yes, Your Honor, may I address that briefly?
Sure.
After I raised that issue, as being something that seemed to be kind of floating around, basically there appears to be an amended pleading in transit. Maybe the U.S. Postal Service has it. Maybe it's still at the jail, I don't know, but he has filed an amended, or attempted to file an amended pleading, so I was suggesting that that's something that all parties of the court may need to have in order to consider what to do about it. And I didn't want the state's assistant state attorney coming over from Tallahassee if there was going to be a continuance. I think Your Honor has looked at the rules and decided that a continuance would not be in order, and therefore everybody was notified by the end of the day that we did need to be here prepared to go forward. May I continue, Judge?
Yes, of course.
I'm sorry that I don't want to get ahead of myself, or more importantly, the court. In discussing this issue, my assignment is on the 2 points of allegations that the court granted the evidentiary hearing on. If he has a pro se filing, which he represents that he does, depending on if the court will allow that matter to go forward, the court may want to allow us to have evidence on that issue in the normal course. If the court's decision, and I don't know what the state's position is, but I think I know, I think the state is going to oppose an amendment to the pleading. If the court agreed with the state on that, it may be efficient to have just to keep the record clear, especially because we don't have his amended pleading, to my knowledge, allow him to make a pro se proffer of what it is he was trying to add so that the record is preserved. And then, if the court thinks it's appropriate, proceed with the regular course of the evidentiary hearing.
What's the state's position?
Your Honor, now that I've had more of an opportunity, of course, to review the pleadings in the case as well as the rule, my position would be is we would object to any amendment, and I would point the court to Judge Ketchell's order striking the defendant's motion for post-conviction relief and motion to invoke 60-day ruling that was e-filed on August 9th of 2023. In that order, Judge Ketchell specifically states on page 2, therefore it is ordered and adjudged, defendant's motion for post-conviction relief is stricken without prejudice to file an amended, properly sworn, facially and legally sufficient Rule 3.850 motion within 60 days from the date of service of this order, if such can be done in good faith. And then more importantly, paragraph 2, if defendant chooses to file an amended motion, the amended motion may only include claims brought in defendant's previous Rule 3850 motion unless the claim satisfies the exceptions stated in Rule 3.850B. The original post-conviction motion was filed by the defendant pro se on January 10th of 2018, and after reviewing it, it seems to only involve the same issue that we are in front of the court for today. So, and having reviewed Rule 3.850B, there are 3 exceptions in that rule that would allow for sort of an extension beyond the usual 2-year time frame. The first one is that the facts weren't aware to the defendant or the defendant's attorney at the time, and they filed the motion or the amendment within 2 years of the new facts being discovered. That the second one is that the fundamental constitutional right asserted was not established within the period provided and has been held to apply retroactively, and the claim is made within 2 years of the date of the mandate of the decision announcing the retroactivity. That does not apply here, nor does the first one. And then the last one would be is that the defendant retained counsel to timely file a 3.850 motion, and through neglect they failed to file the motion. Again, that does not appear to apply. So based on the fact that none of those exceptions apply and that Judge Ketchell made it very clear in his order of August 9th, 2023, that the amended motion could only address the prior allegations, and that's what we're here for, I would object to any amendment at this point, because I think any issue outside of what we're here for today would be irrelevant to that original motion.
I also would like to point out Rule 3.850E, which concerns amendments to the motion. And it states, the first sentence deals with when the court has entered an order granting the defendant an opportunity to amend. Any amendment must be served within 60 days. That was in Judge Ketchell's order that you just referenced. The next sentence in subsection E of the rule is, a motion may otherwise be amended at any time prior to either the entry of an order disposing of the motion or the entry of an order pursuant to subdivision F5, or directing that an answer to the motion be filed pursuant to subsection F6, whichever occurs first. Leave of court is required for the filing of an amendment after the entry of an order pursuant to subdivision F5 or F6. And then it says, notwithstanding the timeliness of an amendment, the court need not consider new factual assertions contained in an amendment unless the amendment is under oath. I don't know if that sentence is relevant here or not, but the next sentence is, new claims for relief contained in an amendment need not be considered by the court unless the amendment is filed within the time frame specified in subdivision B. So I entered an order under subsection F6 on January 7th. And there has been no leave of court sought nor granted for an amendment. So, and there's nothing docketed. I don't know where the proposed amendment is or what it says, but it's untimely.
Could I just make a
Sure.
brief response?
Sure.
The rules are the rules, and I understand the rules. There's also due process and fundamental fairness, which is kind of an overarching concern, but frankly nebulous, and that's why we have specific rules. I understand that. There was language that the court read at the very end about need not be. That to me may leave some implied room for discretion of the court of things that are not necessarily required, but might be permissive. And I respectfully suggest, especially in light of the possibility, and I think fact, that he probably did not have counsel because he wasn't entitled to counsel when he was working on his amended and original motion, that he at least be able to, under oath, state what it is he tried to amend so that the court and the record and the state at least knows what it is he's saying. And then the court can make the decision it wishes as to whether he can go forward.
Any further response?
And certainly I have no objection to that, although obviously I defer to the discretion of the court.
Okay. Let me just check and see, has anything come in? Okay, thank you. We're just checking to see if the document has been received by the clerk yet, because as of yesterday, it had not been.
No, I don't see anything.
Okay, it has not been received. So, Mr. Medina, if you wish to have your client put on the record what it is that, what the amendment was, or what he was trying to include in this amendment that hasn't made it to the clerk yet?
Yes, Your Honor, and two questions in that regard is, number one, is could he be put under oath, just in the abundance of caution that's
Sure.
best?
If you'll just raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, "I do."
I do.
Thank you,
And then
sir.
secondly, because I'm not really calling him as a witness, will the court permit him to sit here and
Yes.
speak to the microphone clearly and loudly so to make sure everybody can hear it?
Yes.
And then go forward as he sees fit, because at this stage, this is a pro se request to amend.
Okay.
Yes, ma'am. I tried to bring paperwork with me from the county jail. They wouldn't allow me to bring paperwork, so sorry if, off the top of my head, the amendment to my amended 3.850, I tried to add a third ground, basically on another downward departure statute that allows, that I was basically never given access to mental health or psychiatrists of any kind when that type of evaluation was ordered, but never an option. And I feel like if we could have done that, that's something that could have helped me personally, whether my sentence was any different or not. Just I was denied those things.
Your Honor, can I ask clarification
Sure,
of him,
sure.
just as an officer of the court?
Sure.
So, just to clarify, because again, you wrote something up and you don't have it with you.
Yes, sir.
And
Yes, sir.
because you mailed the one and only copy
Yes,
to the
sir. Yes, sir.
clerk with a stamp.
Yes, sir. I was in county jail. I hadn't had canteen or anything like that, so I just kind of borrowed an envelope and some paper and wrote a motion. Yes, sir.
Okay, so you did your best to file this.
Yes, sir.
And if I'm understanding you correctly, you're basically trying to amend to add a third ground in your amended motion
Correct.
that says that basically there was a downward departure possibility
Yes, sir.
for, related to mental health?
Yes, sir.
So that's a mitigating factor for mental health?
Yes, sir. Physical or mental disability that is treatable, that allows for downward departure, yes, sir.
That's, Your Honor, I just want to be clear on the record, he's referring to the mental health, mental disability that would be amenable to treatment. And if I may just ask a couple more clarifying questions, Your
Go
Honor.
right ahead.
So you're saying that you didn't get an evaluation by like a licensed psychologist or
Yes, sir.
mental health professional to help you go forward with that if it was
Correct.
supported?
Yes, sir.
And also that that mitigating factor was not raised?
Yes, sir. Correct.
Okay. Thank you, Judge. I just wanted to be clear what he was talking about.
Thank you. All right, now that that's been put on the record, is everyone ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
Okay.
Sorry. Thank you.
All right, Mr. Medina?
Yes,
Go
Your Honor.
ahead.
I would like to proceed by calling my client, Brian Rushmeyer, to testify first.
All right.
Yes, sir.
Your Honor, is it appropriate that he go to the
Yes.
chair? Yeah, I think it'd be better. Thank you. Just follow. Thank you.
And I already swore Mr. Rushmeyer, so he's under oath.
Yes, sir. Just be clear, then put my.
Yes, sir.
Mr. Medina, whenever you're ready, go ahead.
Thank you, Your Honor. Mr. Rushmeyer, would you please state your full name?
Brian Allen Rushmeyer, sir.
And how old are you now?
I'll be 41 in October, 48.
Okay. And you're the defendant in State versus Rushmeyer 14 CF 2354, is that correct?
Correct, sir.
Okay. And you're presently at Okaloosa County Jail for purposes of this evidentiary hearing, is that correct?
Correct.
But prior to coming here, you were, basically, there was an order to transport here. Where were you?
Walton Correctional Institution, sir.
Okay.
In the Phoenix Springs.
Yes, sir. And you're serving what, as far as DOC time, just to be clear, a 20-year
Yes, sir.
prison sentence, followed by 10 years probation. That's the nuts and bolts of the
Yes, sir.
fundamentals of it.
That is
that
correct. Yes, sir.
Okay. All right. The court is very clear on what the hearing is about. There were two issues that an evidentiary hearing was granted on, and you're testifying first, and it's very important that you take this one and only chance to be very clear about all the facts and circumstances about what I'm going to ask you about, okay?
Yes, sir.
Because there's going to be other people to testify,
Right.
and the court probably won't let you come back a second time. So we kind of gonna anticipate things, all right?
Yes, sir.
So, first off, did you and your family hire a private defense lawyer to handle your underlying case?
We did, sir. We hired Mr. Tim Shaw.
Okay. And with respect to Mr. Shaw's representation, is it fair to say there were significant efforts toward work, just in general, before we get to the specifics, there was some significant focus, I'll say, rather than efforts. There was specific focus by you and your lawyer about maybe trying to work out a deal?
Yes, sir.
Okay.
We were looking to sign a deal if the state was willing, and some things were, I guess, going that direction from what it sounded like and what I was told, and then all of a sudden not
Okay, so give the court kind of from what you know about, before we get into those specific things, those two specific things, what are the details on what you were talking to your lawyer about as far as, in general, how you would want to work things out and what you learned from him?
In general, if we're speaking about the same thing, there was an offer from the state for 15 years that was conveyed from the state to Mr. Shaw. I was unable to answer for that. He had told me on the way out of the courtroom that they had offered me 15 years, but that we had a 15-year cap that was going to be in place anyway, so there was no reason to even think about taking the 15 years, that would be my max sentence if that's what Judge Brown decided to give me anyway.
Okay, and this conversation that you had about 15 years, a 15-year offer,
Yes, sir.
had you discussed a 15-year offer with Mr. Shaw at the jail prior to coming to the courthouse?
At the jail, no, sir. It was at the courthouse.
Okay. And now that we're really right on the issues, and I don't want there to be any lack of clarity,
Yes,
okay?
sir.
Because there are two issues. One was relating to your position as to a 15-year offer, and
Yes, sir.
then the other one was as to an issue of a 15-year cap. So
Yes, sir. That was
I
in
don't want there to be any lack of clarity, okay?
Yes, sir. I
So-
ended up signing the plea to the judge, to Mr. Judge Brown, and there was, from what I was told, going to be a 15-year cap on that sentencing guideline, as well as even to this day, I know all my court dockets, if you look at my score sheet, if you look at the felony minute sheet for the day I was sentenced, if you look at anything, on late October of 2013, my charges were enhanced to first-degree felony, using the 775087 case to reclassify my aggravated battery from a second-degree felony to a first-degree felony, if you read the court docs. But if you look at any paperwork except for that one docket, I think it's formal charges, I think it's October 23rd, everything still reads second-degree felony, even to the day of my sentencing. My score sheet still reads second-degree felony. The points still reflect the second-degree felony. Everything is still second-degree felony. Until the day I walked in the courtroom, when I had signed the plea deal, I never heard anything about 36 years. 15 years for the second-degree felony and 5 for the third was the max that I was aware of until that time.
And in fact, so what you're referring to is the fact that, and it's at the clerk's website, the score sheet, Your Honor, I would like to go ahead, just so the record's clear, because he's referring to this score sheet and to some handwriting. I'm going to show it to the state and offer it into evidence. And I have flagged one particular place, but I haven't highlighted anything. Yeah, and then there's this handwriting back there. Okay, did you already do that? Do you want to go ahead and do that? Yeah. Mr. Casey has suggested that the court could go ahead and take judicial notice of the entire court file, and neither side objects to that. Could we ask the court to do that?
The court will do so.
And in that regard, is it easier for the court to find this, or should I go ahead and introduce the score sheet so we're clear on that? Because otherwise, I don't want the court to have to go through pages and pages.
I think I have found it, but maybe so there's no confusion.
Okay, just to be on the safe
Let's go ahead and
side.
get the document.
Thank
If
you,
you
Your
want
Honor.
to introduce the document.
Thank
No-
you.
I'm sorry, no objection to the introduction of the, I guess, defense exhibit number 1.
I guess it'd be, I always get confused, we use numbers or letters, I'm going.
First
Okay,
one.
may I approach that?
Yes, of course.
Which do you prefer?
Gosh, I am just
Typically
I haven't had
letters.
enough coffee, Judge. I thought we used letters.
Typically letters.
Letters.
Oh, okay.
So this would be defendants A?
Right.
Okay,
Just for clarity of the record, Your Honor, no objection to Defense Exhibit A.
all right. Exhibit A is admitted without objection.
Your Honor, may I approach the witness?
Yes.
And I'm sure
Can I take a
the
look
court
at it and make
first-
sure I'm looking at the
Yeah,
right thing?
Make sure we're on the right page.
Yes, I have that on my screen.
Thank you,
Thank
Donna.
you.
May I approach?
Yes.
Okay. Mr. Rushmeyer, you see this score sheet in front of you?
Yes, sir.
So you're stating this was the score sheet that had a couple of places where there were handwritten changes made the day of your court sentencing, is that correct?
Correct, sir. If you look at the original date is 5/14/2015, which is when I signed the plea to the judge, and that was when the score sheet was still second degree and the points were as such.
Okay, so
And- yes, sir.
I'm sorry to interrupt.
And
So
then-
let
yes,
me
sir.
be clear.
I'm sorry, to answer your question, yes, sir, it is the day of my sentencing that it's
Okay,
changed.
and now I want to step back. Prior to the day of your sentencing, there was a day where you entered the plea and sentence agreement that said plea to the bench
Yes, sir.
with Judge Brown. That was a prior hearing, right?
Yes, sir.
And at that time, as I understood it, the court did not accept into the record the score sheet at that point in time. Is that correct?
I believe that is correct, yes, sir. The score sheet was done, but I think there was an issue with, I think Mr. Shaw raised later with the numbers as far
Okay.
as.
But do you know one way or another whether those handwritten changes were made at the day that the court accepted the plea and sentence agreement that said you were pleading to the bench, or were those changes made on the day of the evidentiary hearing? And I don't want you to speculate if you don't know.
No, sir, I'm sorry, I didn't know what you were asking. I believe they were made on 7/20 on my sentencing date. That's when the point issues were brought up by Mr. Shaw. If you look at I'm not sure what the paperwork's called, his document to Judge Brown on what he wanted as far as my sentencing went, he had a corrective action on there, if you look at that as well, saying that the score sheet was wrong, and that's when he changed it by hand, was on 7/20, yes, sir.
Okay, so somehow there was, do you remember of that being discussed about these handwritten changes? When did you first learn about these handwritten changes?
Right there on my sentencing day on 7/20, yes, sir.
Okay, was that before the hearing or after the hearing?
Right, as I came into, I came in the courtroom today and sat next to Mr. Shaw.
And then you saw those changes?
He actually did it right in front of me, sir.
Oh, he made those changes?
I believe so, yes,
Okay.
sir.
And I'm not implying that anything was inappropriate as far as him making changes, but
Yes, sir.
that's when you saw it for the first time?
Yes, sir.
Okay.
He had told me previously in the back room when he met with me that the state was seeking the maximum sentence on everything, and that they were seeking the 35 years, not, and that's when the kind of confusion for me started.
Okay. Now we're back to the day when the plea to the bench agreement was entered, okay?
5/14, yes, sir.
Right. So, and that was what year?
2015, sir.
2015.
Yes, sir.
That day, are you saying, what are you saying about the 15-year offer as opposed to the 15-year cap issue? What specifically did you know about a 15-year offer, and when did you know it? Whether it was that day or the
That's-
day before, be extremely specific about what your testimony is that you can recall.
The day that I came in to sign the plea to the court to plead to Judge Brown in open court is when Mr. Schlechter had offered, he called Mr. Shaw over to the state's desk. They had spoke. When Mr. Shaw came back, he told me that they offered you 15 years, but I told him that don't do us any good when we got a 15-year cap. So we finished the proceedings. He spoke to me a little bit more out the way out the door, and that was it.
Okay, so because I want to be specific. You're saying you're in the courtroom with Judge Brown on the
Yes, sir.
day of where the plea and sentence agreement was accepted for a plea to the bench.
Yes, sir.
Were you maybe it was a different courtroom, but basically you were sitting at the table?
Yes, sir,
and
that's correct.
the lawyer talked to the prosecutor and came over and told you stuff at the table was when you heard about this?
Correct, yes, sir.
Okay. And basically you heard about both issues at more or less in the same conversation?
Well, the 15-year cap that we had discussed many times at the jail as well.
Okay, all right, so we'll come back to that in a second.
Yes.
That's why I'm trying to beat a dead horse here,
Sorry.
because this is your one time to make
Correct.
your testimony clear. As far as the 15-year offer, your testimony, and I wasn't there.
Yes, sir.
I'm not testifying here, but your testimony is the one and only time you heard about a 15-year DOC offer was at the table.
Plea day, yes, sir.
Okay. And to be super specific, what exactly can you recall between you and your lawyer about the 15-year offer that was being or had been rejected?
He, not in an arrogant way, but he kind of told me, he's like, he offered us 15 years and kind of told him to kick rocks because we already have a 15-year cap. So it's,
Okay.
I'm not sure what.
Okay, so when you, in one of your two grounds for this evidentiary hearing, the one where you say an offer was rejected without your being able to make a decision on it yourself,
Yes, sir.
that's the 15-year offer, and that was the conversation relating to that.
At the table on 514, yes, sir.
Okay. Now, there's this other issue that I think you're alluding to about the 15-year cap that you'd had multiple conversations about.
Right.
Okay, so let's step back, give the court your best recollection of each of these conversations that went into the multiple conversations about the 15-year cap, because any or all may be relevant to examining your credibility on that issue.
Right.
Okay.
Basically, there have been several times at the county jail where he told me that the 15-year cap would be put in place before sentencing date, and then in particular the day that he asked that I sign the plea to the judge, where he told me basically that would be my best option as far as my sentencing would be to plead to the judge. He told me that before we stepped in the courtroom, we'd have the 15-year cap. And that was at the county jail. And the last time we spoke about it, I was in the back room prior on the 514 day where I signed, I'm sorry, on my sentencing day, where on 7/20, he came back and told me I didn't get the 15-year cap. The state wants to seek the maximum penalty, and that's what they're going to do. And I never really had a chance to talk to him about it. That was it.
Okay,
And
so,
then the following day, after my sentencing, he showed up to the county jail and basically apologized, saying that he was just dumbfounded, and that was incredible that he didn't see that the state was going to maximize my sentence like that.
I'm sorry, what was the last part?
He didn't think the state was going to, he said it was the worst sentence he ever received in his private practice.
Okay,
And that
now
he didn't think the state was going to.
What I'm concerned there is you may have morphed the two hearings, okay? And I don't want there to be any lack of clarity. This is the time
Yes,
we
sir.
got to be super clear.
I was just trying to bring up every time the 15-year cap was.
Oh, okay,
yes,
all
sir.
right. Now, with respect to the day you entered the plea and sentence agreement that
Yes, sir.
said, plea to the bench.
Yes, sir.
Okay? There were some discussions that I'm sure on cross-examination, the state is going to point out
Yes, sir.
between you and the judge, and also there were some representations made by the then prosecutor,
Right.
then mere mortal Mr. J. Slechter, now
Mr.
circuit
Slechter,
judge,
yes.
of course. But he
Yes, sir.
made statements too about the maximum sentence, okay?
Yes, sir. He made
So-
statements that 36 years, I believe, is the maximum. So that was obviously a question I have for Mr. Shaw afterwards.
Okay, so now I'm cutting in here,
Yes, sir.
because I want to give I want to have there be clarity. With respect to the 36 years, 35 years, anything beyond 15 years, was that the first time you were hearing about it in the courtroom then?
Yes, sir.
Okay. Because you'd only had conversations before then about there was going to be a 15-year cap with respect to the
Yes, sir.
plea to the bench.
On the original score sheet, it does say 20 years max, but from what I understood and what I believe the score sheet reads, that's the 15-year max for the second-degree felony and the 5 years for the third-degree felony of aggravated assault. So the score sheet I knew read 20 years, but with what I'd been told the whole time, 15 is what I thought was the max. Yes, sir.
Okay, so you had this basically then just typewritten, not hand-edited version
Yes, sir.
that had basically maximum sentences of 20 years.
20 years, yes, sir.
And you're saying, your testimony, and I'm not trying to lead you, okay? You're saying what about the day of when the plea to the bench hearing happened?
That's what made me
What,
bring it.
are you saying before you came in, you had a conversation in the attorney-client that day, or was that only after about the cap?
The 15-year cap had been discussed several times, but it was especially discussed after the 36 years came up, because I was unaware of 36 years. So I made sure to ask Mr. Shaw about it.
Okay,
then
and was
as well.
that, when was that conversation to ask him about that?
On the way out of the courtroom.
On the way, like, basically as you're at the table
Yes,
getting
sir.
up and leaving?
Yes, sir.
Okay. And specifically, what was the conversation that you can recall?
That I was concerned of the 36 years, and that he told me not to worry about it. They were going to have a 15-year cap.
Okay. All right. Is there anything else about the 15-year cap that you feel you need to tell the court about so that you have given all the information as to the 15-year cap? Because I don't want there to be any lack of opportunity for you.
I don't believe so, no, sir.
You did state that there was a follow-up meeting at the jail, but that was after sentencing. Is that
After I was
correct?
already sentenced, yes, sir, the following day.
Okay.
So 7/21/15.
All right. So are you saying that the day the plea and sentence agreement was entered, you, as you're leaving the courtroom, had a conversation about you're still thinking there was going to be a 15-year cap?
Yes, sir.
And when did you for sure learn there was not going to be a 15-year cap?
On 7/20, just before I entered the courtroom.
Just before you went in to be sentenced?
Yes, sir.
And what specifically can you recall about that conversation?
Mr. Shaw basically came back there and told me, like I told you, that the state's seeking the maximum penalty. He said, I know you're remorseful. He said, I know I don't know what to tell you, and basically that was it. He said, the state's going to give you the max, that's it. So I literally couldn't speak through the processes. I was pretty much crying the whole time. I didn't know what to think.
Okay. Now, this hearing is not about your mental capacity,
Yes, sir.
but were you capable of being do you have PTSD?
I believe I have some sort of mental disorder, sir.
Okay. And you were in the United States Marine Corps for 5 years?
Yes, sir, a little
Okay.
bit more.
And you were not in combat,
No, sir.
but you had a lot of traumatic experiences from that?
Yes, sir.
Is that right? Okay, so, were you upset when you learned there was not going to be a cap?
Absolutely.
Okay, and so you're saying you brought those emotions into the courtroom?
Yes, sir.
And you were more fearful and emotional because for the very reason you thought before there was going to
Object to
be.
leading.
Sustained.
Good. But you were learned for the first time then there wasn't going to be a 15-year cap.
Correct.
All right, no further questions. Thank you.
Cross.
Thank you, Your Honor. Good morning.
Morning, sir.
Is your name pronounced, is it Rushmeyer?
Rushmore, yes, sir.
Okay, I don't know why I want to call it Rushmeyer, but it's just Rushmeyer. So really just take the C out of there and
Take
pronounce
it
it.
out of there, yes, sir. Very easy name.
All right.
No, I'm just kidding.
Even I hopefully can't screw it up. So Mr. Rushmeyer, have you ever been diagnosed, by a professional with PTSD?
Whenever I got out, sir, I was only out for 11 months before this happened. I was in the process of seeing the VA and going through my appointments. So no, I've never been diagnosed.
And so Mr. Shaw wouldn't have had any records of treatment that would have reflected that diagnosis at the time you were sentenced, correct?
No, sir. Only pending appointments and things as such. I was set up for evaluations, but I haven't been able to make them in that time yet.
Okay. And you indicated that Mr. Shaw, on the date of sentencing, which was July 20th of 2015, advised you that the state was seeking the maximum of 36 years?
Yes, sir.
Okay. So were you aware that Mr. Schlechter, the prosecutor at the time, had authored a memo to the court asking for the exact sentence that you received, the 20 years followed by 10 years?
Yes, I was aware that morning. I had it on the table during that hearing, yes, sir.
Okay. So I'm confused. Was it your understanding the day of your sentencing that Mr. Schlechter was asking for 20 years followed by 10 years, or that he was asking for 36 years?
No, when Mr. Shaw came in the back, he told me the state was seeking the maximum penalty. I didn't hear the reading of that paperwork you're talking about or see it until I was in the court that day, in my sentencing hearing, there at the table.
Okay. So you're saying, in other words, that Mr. Shaw misadvised you about what the state was seeking, if I'm understanding correct?
I guess in a way, yes, I wasn't thinking of it that way. So yes, it's instead of 30 years, 36 is what he was telling me. So yes.
Okay. And just to be clear again for the record, make sure that I understood, the court understood, you're indicating that the only time you heard about the 15-year state prison firm offer from the state was on the day that you entered the straight-up plea to Judge Brown.
Yes, sir.
So you don't recall there being a prior court date on May 8th where that may have been discussed between the two of you?
No, sir, I do not recall it.
Okay. And when you entered the plea on May 14th, 2015, didn't Mr. Shaw go over the plea form with you?
I'm sorry, say again. When I entered the plea on May,
Well, actually, I guess scratch that question. Isn't it true that Mr. Shaw came out and visited you at the jail on May 13th, the day before
that's true.
court?
Yes, sir.
And didn't he go over the plea form with you at that time?
Yes, sir.
And didn't you notice that on the plea form, there was no mention of a 15-year cap, correct?
Not on the plea form, sir, but Mr. Shaw assured me that we would have a 15-year cap when we walked into the courtroom.
Okay. And do you recall being questioned by Judge Brown about, accepting or pleading to him?
Yes, sir, I do recall.
And didn't he ask you, had any promises or threats or anything like that been made to you to get you to enter the plea? And then you answered no, correct?
Yes, sir, that's correct.
So despite the fact that Mr. Shaw had promised you there'd be a 15-year sentencing cap, despite the fact it was nowhere to be found on the plea form, and despite the fact that Judge Brown specifically asked you if those kind of promises had been made to you, you answered no.
I don't believe if any promises made as far as the cap came up, but the promises as far as, I don't really know how to answer that, sir, except for Mr. Shaw was my paid attorney, and I had all faith in everything he told me. So when he told me that it was a 15-year cap, that's how I understood it would happen.
How far did you go through school, Mr. Rushmeyer?
Just high school, sir.
But you did get your high school diploma?
Yes, sir.
Any difficulty in reading or writing?
No, sir.
You were able to write both your original motion and your amended motion, correct?
With a lot of help, yes, sir.
Okay. So you didn't have any problem understanding the plea form when you read it on May 13th, 2015, did you?
I mean, understanding the way that you guys understand it, yes, anyone would. You guys go through extensive school and are very intelligent people. That's not beyond me. So if you're asking would I understand it to the same extent that you would, sir, no.
I guess what I'm asking you is not necessarily that question, but
Yes, sir.
did you feel you understood what you were signing on May 13th?
I thought I did, yes, sir, but apparently not.
Okay, and again, you didn't ask Mr. Shaw any questions on the 13th about, hey, why isn't the 15-year cap on the form?
Oh, yes, sir, I did. He just assured me that it would be there, the 15-year cap would be in place when we enter the courtroom.
Okay, and then when Judge Brown was accepting the plea on May 14th, and there's no mention of the 15-year cap as part of that process, that didn't cause you to say, hey, Judge, wait a minute, I can't get 36 years. My understanding is the most I can get is 15 years. You didn't say that, did you?
No, sir, I did not.
And again, I think Mr. Schlechter made it clear on the record that by entering the straight-up plea, you were facing up to 36 years, correct?
Yes, sir.
And I believe Judge Brown actually made it very clear and said that you were facing 36 years. I think he initially said 36 years in prison, then corrected himself to say 35 years in prison and 1 year in county jail. Do you recall that?
Yes, sir.
Okay, and despite being told that by the prosecutor, by the judge, on the record, you didn't raise any concern about entering your plea that day without a 15-year cap being mentioned?
Not openly to the court, no, sir, just to my attorney.
Okay. That's all I have, Your Honor.
Any redirect?
Is there, two questions. Number
Yes, sir.
one, is there, based on the questions that you've heard from by the prosecutor, Mr. Casey, is there anything you need to clarify or change from your direct testimony with me?
No, sir, I'm just trying not to get confused with the dates and whatnot. That's kind of throwing me back and forth, but
Okay.
no, sir.
Anything more you wanted to advise the court about pertaining to this matter?
No, sir.
Okay. No further question, Your Honor.
Thank you, sir. You can go back to your
Yes,
seat.
Mr. Medina, your next witness?
Yes, Your Honor. I would call Mr. Tinshaw.
Okay. Oh, yes, thank you. There is, Defense Exhibit A is being handed to Madam Clerk.
Thank you, Your Honor.
All right, Mr. Medina, you may need to go get Mr. Shaw.
Oh, I'm sorry,
that's
Judge.
okay. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do. Thank you, sir. Just have a seat and state your name clearly into the microphone.
Tim Shaw.
All right?
Thank you. So, Mr. Shaw, would you state for the record one more time your name and where you work?
Yeah, Timothy Shaw, Anchor Smith Grimsley.
And were you the trial counsel for Mr. Rushmeyer, Brian Rushmeyer, the defendant?
I was.
Okay. Have you talked about this amended motion and the two issues that we're supposed to have an evidentiary hearing about today.
Yes.
Okay. One of the issues, what I want you to do is give the court full understanding on these two issues in your own words, okay? So there is an allegation by Mr. Rushmeyer that he was not informed about a 15-year offer until more or less you had rejected a 15-year offer from then prosecutor Jay Slechter. Can you tell the court what you know about a 15-year offer, whatever you can recall about that situation?
As I recall, and to the best of my recollection, I think it was about 10 years ago now, that my thought was it was a 12-year offer, but, you know, I could be wrong in thinking about a different case, but I've never turned down an offer for a client without letting them know, you know, here's the offer, what do you want to do? It's always the client's decision. I do not recall turning down an offer. Now, I can tell you this, with the score sheet and the judge that we had and having some experience with that, I would have probably said a 15-year offer or 12-year offer is probably more than I expected him to get.
Okay. So, not to put words in your mouth, Mr. Shaw, but basically, you're testifying to how you normally do things, and also to a limited extent, you have some specific recollection.
Yeah, and I think I mentioned to you before when we
Yes,
talked about this, I don't have a specific recollection of that conversation that he's referencing in his motion about coming out of a courtroom and saying, I turned down this offer, you know, and because that's just not me. That's just not something I've ever done in my practice, to turn down an offer for somebody. Now, I frequently get offers from the state and discuss offers with the state, discuss it with clients, and I give my opinion as to whether or not I think it's a good offer or a bad offer, you know. And I could see that happening in this case, that I thought it was. I certainly, as I sit here today, this is one of those cases I look back on in your career and say, that sentence was way too high. That's just.
And this was the sentence that ultimately was imposed was very professionally, it hurt you as you're a human being and a caring lawyer.
Yeah, absolutely, absolutely. I still think it. Thought about it many, many times. I've had cases where I've got dead bodies that didn't get that long.
And in fact, when you heard Mr. Rushmeyer was coming back, you came up to me at the courthouse and said you had always been troubled by that.
Absolutely.
Now, there was also an issue raised by Mr. Rushmeyer of this 15-year cap issue. What, if anything, can you recall about a discussion, if any, about a 15-year cap, if you have any recollection at all?
I don't have a recollection of a specific conversation about a 15-year cap. It is, and again, thinking back on it, I can certainly tell you that if that issue came up, I would have approached it with the state and said, hey, can we put this in this plea agreement? And then you see the plea agreement doesn't have that in there. So obviously, if the discussion was had, it was not an agreement with the state. And so we pled to the court, fully expecting to get something. I fully expected to get something for Mr. Rushmeyer closer to the guidelines.
Okay. And what were the guidelines? Do you remember?
I believe it was 70 months.
Okay. Okay, so.
In that range, yeah.
Right. Like 70 months would be, my math is terrible, but basically that would be half of the 12 years that you were
That's right.
testifying you thought to.
That's right.
Okay, just because I want to take this opportunity, can you recall anything about making handwritten changes to his score sheet? Because the typed up version said 20-year max and a second degree felony being the primary offense, and apparently there were handwritten changes. Do you remember anything about that?
No, I don't. I don't have any independent recollection of that.
Can I just, Your Honor, can I see Exhibit A?
Yes.
And show the witness just so we can see if it's his handwriting?
Yes, of
May
course.
I approach?
Of course.
Thank you. So, Mr. Shaw, just if you'll look at this and see if that might be your handwriting.
That does not look like my hand, that does not look like my handwriting.
And then there's also a, yes,
Yeah.
that on that last page. Does that look like your handwriting?
That doesn't look like my handwriting.
Okay, so to be clear, I'm sorry, Judge, because there's actually, clearly Judge Brown's doing his signature on the last page.
Right.
And clearly Judge Brown is the one who, well, I assume that was him that was actually writing the actual sentence that he imposed.
That does look like
20
his-
years and the 10 years.
Yeah, sorry.
So
That does look like his handwriting.
I'm sorry, Judge, to be in the witness's personal space.
Oh, you're fine.
I'm not just trying to, but basically the 20 and the 10 and the judge's signature and the X's by the 20 and the 10, it does stand to reason that that was written by Judge Brown
Correct.
at the day of the sentencing when he was making that decision.
I would agree with that.
And then the 35, though, it looks like a different pen, like a different writing maybe.
It appears to be a different pen.
Yeah, and so you can't sit here today and say who wrote 35 and over 20.
I can't.
Okay, thank you. Your Honor, may I provide this back to the clerk?
Yes.
Thank you. I don't have any other questions, Your Honor. Thank you.
All right. Mr. Casey?
Good morning.
Morning.
Let me ask you, do you recall, and again, I know it's been a long time ago, do you recall after the defendant receiving the sentence that, because both of you are obviously very disappointed in the outcome, do you recall filing a motion for modification or reduction of sentence after the fact?
Yeah, I do.
And do you recall whether you had a hearing on that or the judge simply issued a written order?
I remember seeing the order. I can't remember if we actually had a hearing on it or he just ruled based on the pleadings.
And would you have, again, as best as you recall, would you have discussed filing that motion with the defendant?
Either him or his family, because I think that came back after the appeal.
Okay. And ultimately, your recollection would be is that Judge Brown denied that motion?
That's correct.
And do you ever recall your client mentioning to you, that, hey, what happened to the 15-year cap that was supposed to be in place?
I don't recall that.
And do you feel confident that if you had told your client on the way out of court, hey, we've got to offer 15 years, I told the state no way, if you had said that, do you feel confident you would recall that?
Yeah, and again, 10 years ago, any discussions I would have had, I can't recall specifically, but I can tell you, as I said earlier, that I don't turn down offers without talking to my client first. Now, I probably said they gave you a 15-year offer, and I think that's too high, for sure, yeah.
And putting that into context, at the time, knowing that the guidelines was at 70 months, a little less than 6 years, you probably, do you agree, you probably would have told your client, 15 compared to the bottom of the guidelines, seems like a high number.
Yeah, and the things that we had to argue, we had a lot of family support. We had them come in and testify at sentencing. His military record, we provided that to the court. I felt confident he wasn't going to get that much.
Okay. Do you have any other information regarding the defendant's allegations that we haven't already discussed, either with Mr. Medina or with me?
No, and I went back and looked through my file after I got subpoenaed for the hearing and looked through my file to see if I had any notes in there about these specific allegations, and I couldn't find anything.
That's all I have, Your Honor.
Any redirect?
No, Your Honor.
May the witness be excused.
Yes, Your Honor.
Thank
As far as he's been subpoenaed by both sides, probably.
Oh,
Right. Yeah, I have no objection to him being released, Your Honor.
thank you, Mr. Shaw, you're free to go.
Thank you.
Thank you, Mr. Shaw. Your Honor, may I call Rick Rushmeyer, the father of Mr.
Sure, go
Rushmeyer?
ahead.
And just for the court and planning purposes in the state, I'm not intending to call Miss Rushmeyer, the mother, Deborah. It's just going to be Rick for some brief testimony.
Okay,
I'll go get her.
all right, thank you.
All right, thank you, Mr. Shaw.
Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you, sir. Just have a seat, and if you'll just state your name into the microphone, please. Could just state
Oh, I'm
your
sorry,
name into
Judge.
the microphone. State your name.
Ricky Rushmeyer.
Thank
I'm
you.
sorry, I'm real hard of hearing.
Oh, thank you, sir. Go
You're
ahead.
not the only one, Mr. Rushmeyer, so don't feel bad, okay? So, Your Honor, Mr. Rushmeyer, what is your name and where do you live?
I'm Ricky Rushmeyer, Fort Walton Beach, Florida.
Okay. And you've lived here a long time and worked here a long time, is that correct?
I've worked at Prestonwood Chevrolet for 40 years and lived here about that long.
Well, thank you for your work for our community. Do you have your son Brian in the courtroom?
Yes, sir.
Okay. I'm here to talk to you not about rehashing his prior hearing, but to talk about a real specific couple of issues, okay? So I'm going to first ask you, do you have any recollection about any discussion with Mr. Shaw about a 15-year offer or any other type of years of offer?
I think what it was called was a 15-year cap,
Okay.
which I didn't know, still don't know exactly what that is. So somebody says a 15-year cap, I think that's 15 years is all you can do. I don't know what it means.
Okay. Okay, so that you don't remember a discussion, now I'm not trying to suggest that you should. I just want to be clear what you are going to be able to talk about. You don't have any recollection about a 15-year DOC prison offer.
No, sir. Like I said, I didn't know what the 15-year cap meant. So
Okay, all right, so we're going to talk about the 15-year cap then. Because you recall some discussion about a 15-year cap, that terminology.
when we went into his office the day of the trial before we went to the court,
The day of the sentencing?
yes, there was this talk. There was two talks of two different numbers, and at this point, when I first went in office, we're talking about, and we're worried about how long we're going to lose our son, number one. And he told me he thought it was a 6 to 10 year sentence. And then later on in the conversation, he said he was going to try to do a 15-year cap or whatever that meant. So it was a very short conversation before we come to sentencing.
Okay. And where were you when this conversation happened?
In Tim's office on Hospital Drive there, or whatever that is.
Okay, all right, okay. Is there any more about this? Because I don't want to beat a dead horse. If you can't remember anything more specific about that than I've already asked you.
Not really. I mean, like I said, when somebody tells me that, I guess my perception of what I thought a 15-year cap meant was the sentence would not go over 15 years.
Okay. But you did not have a conversation of that nature on any day other than the sentencing day with Mr. Shaw, is that right?
Correct.
So you can be sure that whatever conversation you had with him of this nature was on the actual day of the sentencing.
Yes, sir.
And you were talking to him about, in part, what you were going to be testifying about at the sentencing hearing? Is that possible? Was that a topic?
Yeah, a little bit. We talked about that, and just basically all they told us to do was get them.
And then basically everybody got in the vehicles and drove for a very nervous ride to the courthouse?
Yes, sir.
And the rest is history?
Yes, sir. Bad history.
Yes, sir. No further questions, Judge.
Mr. Pacey?
No questions, Your Honor.
All right, may the witness be released.
Yes, Your Honor.
Thank you, sir. You're free to go.
All right.
Any further witnesses from the defense? Sure.
For the defense, Your Honor.
All right. State?
We have no witnesses based on Mr. Shaw having already testified, Your Honor.
All right. Both sides ready for argument?
Yes, Your Honor. Do you want to allow, is it okay if we allow the witnesses in?
I was going to say, if there's no more testimony, then Mr. Rushmeyer's parents
Do you mind
probably,
if I go get them?
go ahead. All right, Mr. Medina, whenever you're ready.
Yes, Your Honor. Basically, as far as the standard of review, the burden, and so forth, I think that those matters are fairly put forward in the amended 3.850 motion for post-conviction release, so I'm not really going to argue the law. I'm just going to make a brief argument about the facts as I see them, and of course the state may disagree, and the court is the trier of fact on these issues. But when lawyers talk to clients in the heat of the battle, there are possibilities of nuances and ambiguities that the lawyer, the person in my shoes, it's perfectly clear to us. But sometimes things are not perfectly clear to the person sitting in orange. And we do our best. We try very hard, whether it's a private lawyer like Mr. Shaw, who I have a great respect for, just a fantastic lawyer in person, or me. I'm not as good as him as a human being or as a lawyer, but I make my mistakes too, and I do my best to advise people like Mr. Rushmeyer, and sometimes we wish we could do better. I do think that there's clarity from Mr. Rushmeyer's testimony, corroborated by his father. I think this is a situation where there was not clarity of communication on that day, where facts and circumstances were in flux that basically heightened the sense of confusion, including a score sheet that was not clear on the, possibly, according to Mr. Rushmeyer, and not contradicted by Mr. Shaw, up through the the time of the sentencing hearing, there was changes being made to the score sheet. So it's a situation, Your Honor, where I think that it is one of those exceptional situations where I do think that Mr. Rushmeyer should be resentenced. The process should go over as to sentencing because going back to the legal standard, I said I wasn't going to argue it, but basically is that there is a reasonable probability that a mistake was made, and it's a reasonable possibility that it's accepted this person, this imperfect human being, but he has served his country. He has a wonderful family. It was a devastating outcome to his private lawyer, who's a great person. And I think in the interest of justice, I respectfully request the court to let him be resentenced. Let's have a procedure that we're sure is fair and fully advised. Thank you.
Thank you. Mr. Casey?
May it please the court, counsel? Your Honor, I'll fight my natural inclination and try to keep this fairly concise. You know, I think the testimony from Mr. Shaw a while ago, you know, completely rebuts the claims that were made by Mr. Rushmeyer in his amended motion, and prior to that, his original motion. You know, he was very decisive in saying that, you know, again, just reading from Mr. Rushmeyer's motion, he says, the state offered defense a 15-year prison sentence. Defendant was not made aware of this offer in court. Upon exiting the courtroom, trial counsel stated the following to the defendant: the state just made you a plea offer of 15 years, and I told them no way. Defendant advised trial counsel he was willing to take the state's offer. Trial counsel advised the defendant, I can get a better deal than that. And I would note also that he does say that occurred on May 8th of 2015 in the amended motion, which was not the date of the plea being taken, which was May 14th, 2015, as well as not the date of the sentence, which was July 20th, 2015. So I think, you know, again, the fact that Mr. Rushmeyer was confused as to when this alleged statement was made goes to his credibility, or in this instance, lack thereof, because you know, he's confusing it. And granted, I know we're 10 years removed, so there is that. But again, as I think a lot of defense attorneys have pointed out, defendants seem to remember details better than the defense attorney because it's the only case that they have. And yet he wrote in his motion May 8th and testified today that occurred on May 14th. And so when Mr. Shaw is very clear and firm and confident on the stand and saying that, you know, I didn't say that. Granted, I don't remember the exact conversations about the plea. Again, he indicated he thought he maybe had a 12-year offer instead of a 15-year offer. Either way, he was very adamant that conversation never occurred and that he would never turn down an offer without running it by his client. And so I feel confident that that is exactly what occurred. And then, of course, on the case law, or under the case law, there is a presumption of effective counsel unless the defense is able to show that there is a deficiency. And so, you know, as to that particular allegation, I feel they've not met their burden and the motion should be denied. And then as to the 15-year sentencing cap, again, trying to kind of be brief, I would note that when the defendant's father just testified, you know, he indicated, in the words that I heard him say, was he was going to try to do a 15-year cap and that a 6 to 10-year sentence was likely. And of course, I defer to the record and what the court heard, but that's what I wrote, that's what I heard. And I was obviously listening very closely since I suspected there would be some testimony relating to communications with Mr. Shaw. So again, trying to do a 15-year cap is very different than saying, you know, you've got a 15-year cap. That's the most a judge can do to you. And I think, you know, as I would defer a lot as well to my response that I filed in the case. and would ask the court, of course, to look at that and review the plea form and the transcript that I attached as exhibits. Of course, since the court's taken judicial notice of the court file, they're in there as well. But I did specifically put those and reference those in my response where, and of course asked the defendant today about them, you know, like, you signed a plea form, you're not, you know, obviously he's not, he's an intelligent human being, he's got his high school degree, he was able to write the motion and the amended motion, albeit I'm sure he may have had some help while he was incarcerated, but you know, to be honest, I mean, the motions are as well written as I generally see, if not better than most of the motions I see that are pro se. So again, I don't think we're talking about a person that struggles to understand. And again, Mr. Shaw went out to see the defendant the day before, went over the form with him. You know, he indicated, you know, he signed the form but expected the 15-year cap to show up later on the form. It didn't. The judge asked him about it on the record, have you been promised anything? He said no. I mean, I don't know what is more clear than a judge asking you, have you been promised anything? Because essentially he's coming in here today saying, my attorney promised me that 15 years was the cap, yet it's not on the plea form. When asked by Judge Brown that question, he does not bring that up. He doesn't say, hey, the prosecutor just said I'm facing 36 years. You just said I'm facing 35 years in prison plus 1 year in jail, 36 years. That's not what I've been told. I've been told by Mr. Shaw that 15 years is the most I can get. And again, none of that is brought up. You know, it's not on the plea form that he signed. It's not brought up at all when he's questioned by Judge Brown. And again, that transcript is the exhibit number 2 that I attached to the state's response. So again, I would argue to the court that, you know, it's not very reasonable to believe that he would have not said anything and just trusted that this 15 years was magically there without anybody saying anything about it. And after twice being told the day of his plea, May 14th, that he was facing up to 36 years, both by the prosecutor and the judge, I just don't think his testimony is credible. And I would ask that the court deny the motion regarding the 15-year cap too. And again, today it seems like the allegation from the defendant kind of morphed together. Originally there were these, again, the way I read it, 2 allegations. One is we got a 15-year offer on May 8th. He turned it down without telling me about it. And then on May 14th, and thereafter, I expected there to be a 15-year cap, and there wasn't one, and I got 20 years followed by 10 years. And it was, you know, on the 14th where, you know, he seems to indicate that the offer was made, he took the plea straight up, and he's taken the plea because Mr. Shaw told him there was a 15-year cap. And of course, he's right. Logically, it would make no sense to take a 15-year plea offer that day when you're being told, if you were being told that there was a 15-year cap. But again, I think the record is silent on that. In fact, I think the record is very clear. What he was being told is that he was facing up to 36 years. So I'll try to, again, I know I'm probably run over the line of being concise, but just to sum it up, Your Honor, again, we're asking that the court deny the motion. I think what really happened here, and this is coming from someone who's worked on both sides of the aisle. I was a public defender for 1 year. I was in private practice for 12 plus years, doing mostly defense work. Before that, I was a prosecutor in Tallahassee as well as this circuit, and this is my second go-around with the circuit. So I've been on both sides and discussed plea offers and situations with clients many times, as well as made offers many times. I think what essentially happened here, and often happens in a case like this, where the outcome is not one that the defendant wanted, the defendant's family wanted, the defense attorney wanted, the family tends, and the client tends to focus on, you know, the positives of what you're saying. Hey, you score 70 months. This is a case that's more like 6 to 10 years. The odds of you getting 36 years, you know, no way. You know, the odds of you even getting 15 years, you know, should be no way. You know, I think, you know, even though it wasn't testified this way, I think the conversations that were had and sort of alluded to by Mr. Shaw was, You know, there was what he expected to have happen, certainly what the defendant and his family expected to have happen, and then there was what actually happened. And again, I don't think Mr. Shaw was ineffective in advising the client that, you know, 15 seems high when he scores 70 months. Based on his experience with Judge Brown, he felt like the plea straight up was the better option. But I would submit to the court that's the decision the defendant made, was to take that risk. And then, unfortunately, it didn't turn out, because instead of getting 15 years or less, which was what was hoped, he got the 20 years followed by the 10 years. And again, I would just submit to the court that's because Judge Brown looked at it, and you had you know, a stranger getting hit in the head with a rusty meat cleaver with 16 stitches. You had another stranger, a female, having to jump in the water to avoid also getting hit with the rusty meat cleaver. And then you've got the defendant running and getting into a fight with a fisherman and battering a fisherman. And all this happened in a very short amount of time, and there's blood all over the victim's face. The PSI, which is referenced which is in the court file, and I would refer the court to take a look at as well. The probation officer contacted the victim, and the victim indicated that he thought the defendant should get the maximum because he could have been killed, because he was hit in the head with a rusty meat cleaver and had 16 stitches and missed work. So I think once Judge Brown took all that into account, despite Mr. Shaw's experience with Judge Brown and the hope that the defendant scoring only 70 months would receive less than 15 years, that didn't happen. And obviously afterwards the defendant's upset, the family's upset, Mr. Shaw's upset. But to say that he was ineffective in suggesting that, you know, and that's really not exactly what the defendant is saying, but I would submit to the court that if we even go beyond the allegations, which I think have been disproven today, if you just say, hey, was it ineffectiveness to recommend a plea straight up to Judge Brown in this situation, then I would submit to the court it's not. You know, we can't, all we can do is give our best educated guess, our best advice of what we think is going to happen, and do our best to put on the best arguments we can, the best presentation we can, to try to convince and persuade the judge to rule in our favor, or at least as favorably as possible. In this instance, it would have been 70 months. I believe Mr. Shaw did that. I think really everybody here probably believes Mr. Shaw did that. And unfortunately, you know, he was not able to persuade Judge Brown to do the bottom, or to do less than the 20 years and the 10 years. And that's exactly what Mr. Schlechter recommended. And I do think, just briefly, it is relevant to mention that, again, there's an inconsistency by the defendant when he says, hey, he's telling me that the state's asking for the max, the state's asking for the max. Well, that doesn't make any sense. If he's offering 15 years, now he's offering 36 years, or he's pushing for 36 years, and the record clearly refutes that. There's a memo from Mr. Schlechter, and what Mr. Schlechter asked for, even after the 15 years had been turned down, is 20 years prison followed by 10 years probation. And that's exactly what the defendant received. He did not receive the maximum. There's nothing in the record to suggest the state ever sought the maximum. So again, I would submit to the court that I think there's a lack of credibility in that testimony. Again, I suspect the actual discussion was, hey, not only is he no longer offering the 15 years, now he's asking for 20 followed by 10. That's totally ridiculous. That's way too out of bounds. I don't think you're going to get that. But the reality is in the plea form and the colloquy make it clear that he was aware he could receive up to 36 years. So based on all of that, I'm asking the court to deny the motion. Thank you.
Thank you. Mr. Medina, anything further?
Yes, Judge, very briefly.
Go ahead.
The fact is, nobody here was in conversations with Mr. Shaw other than Mr. Shaw testified and really can't remember the specifics. The father, who's very credible, remembering something he's never discussed 15-year maxes before in his whole life, and he's talking about hearing this concept of 15-year max. He's not lying. He heard that the day of the sentencing. It corroborates Mr. Rushmeyer, who's admittedly 10 years later confused May 8th and May 14th, but that does not undercut the central credibility of his testimony either. And there was confusion in terms of the max. The actual score sheet max was what Mr. Slechter was asking for. Of when they went in there, that score sheet apparently showed 20 years. At some point in time, it was hand edited by somebody. We're not exactly sure who. But the max was what the state was asking for of the 20 years. So that's really doesn't undercut his credibility. But the final point is that this question, we went through this recently with respect to a mentally incapacitated person where a plea was withdrawn and a competency eval process was going to transpire. But basically, the question isn't, in this proceeding, the effectiveness of the colloquy between the judge, I don't mean to point judge, between the judge, Judge Brown, and Mr. Rushmeyer that day. It wasn't the effectiveness of the prosecutor in stating some things on the record. It was the effectiveness of the communication by the lawyer to the client. And I respectfully submit that as to that question, there is a reasonable probability, which is what the standard review is, there's a reasonable probability that there was a problem of that effectiveness. And that effective line of communication was not there. Thank you.
Thank you. I'm going to review the motion and the answer again. I've read everything before court. I'm going to review the legal authority, and I'm going to review the court file again, and I'll issue a written order. So I'm going to take this under advisement.
Thank you, Aaron.
Thank you all very much.
Your
Good
Honor,
luck to you, sir.
Could Mr. Rushmeyer go back and remain at the jail until the court issues a decision?
It could be, it's not going to be tomorrow or anything. It's going to be,
What I meant was, without him transporting back to DOC facility, Walton County, can he stay at the jail pending this process? We've had our evidentiary hearing. Can he stay here until the written order comes out in the Okaloosa County Jail, or does he need to transport immediately now back to Walton County?
well, I'm going to have to do a relatively detailed order. I can't just say the motion is granted or denied.
Yes, Judge.
So what I'm getting at is it's going to take some time to write that order. I mean, how long are you thinking?
Oh, no, I was just
Yeah.
asking, is it the court's direction that he remain here or that he go back?
Well, I
just
was
want him to
thinking-
comply with.
I was
whatever.
thinking go back. Are
Okay.
you wanting him to stay?
I'm thinking just ask him if there
Sure,
was any-
sure. Okay,
Because he gets game time there, I'm not sure how it works here, so.
right. Okay, so sir, you'll be taken back to your facility. Okay, it's probably going to be at least 30 days
Of
before I can
course.
get that order done, at least.
Thank you, Your Honor.
Sure.
Right this way, sir.
Thank you all.
Thank you, Your Honor. Have a good day.
Thank you. Thank you very much.
Take care. See you.
So we have other matters on our morning docket, although I believe Madam Clerk has been in court since about 8:30 this morning. I've been in court since 9. We're going to take a brief break, and we're going to come back and handle the rest of our hearings. Okay?
Thank you, Your Honor.
Thank you.
All rise, please.
No, I'm just asking.
Black-owned bakery cafe is 2 blocks from the courthouse on Crestvview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll.
Fight fire with fire, take one.
Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Whoa!
Not cool, bro. I'm attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
That's not. Yeah, you're not. I just filed on it today. I was up until 11 last night filing information.
I'm sorry, Brown would be Rachel, right?
Yeah.
Okay.
Yeah. Hey, Christine.
Hi. Well, I guess not. Jessica's here. I'll go. No, I didn't see her. Actually, I'll go now one more. Do you want the end or do you want the middle? Because that's all we got right now.
It's a motion to modify bond.
Yes, Your Honor. Mr. Harville just walked in. If I could have a second.
Okay.
Your Honor, Ms. Garrett's not here on my case yet, so
Okay.
when she gets here with her witness, we'll let you know.
Thank you. All right. So again, case 25 CF 1100. We are here on the defendant's motion to modify bond and pretrial services condition, which I read, and essentially Mr. Harville is asking for the bond condition of no contact with the victim be modified to no violent contact. Is that right?
Yes, Your Honor.
All right, what's the state's position?
Your Honor, the state objects.
Okay. Who's going to present testimony on this?
We both will, Your Honor, but I'll let the state go first, because that was their objective.
Okay,
Your Honor, the state calls Mr. Kent Moore.
okay.
You can follow.
Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you, sir. Just have a seat and then state your name into the microphone.
Kent Stephen Moore.
Thank you, sir. And did you contact law enforcement on May 31st of 2025?
Yes, I did.
Okay. Did you witness an incident on that date around approximately 3 p.m.?
I couldn't hear.
Did you witness an incident on that date around approximately 3 p.m.?
Yes, my neighbors were having a violent disagreement in the parking lot.
And where did this incident occur?
Do what?
Where did this incident occur?
288 Kidd Street?
And is that in Okaloosa County?
Yes, Fort Walton Beach.
Is the individual that you called law enforcement on in the courtroom today?
Yes.
Okay. And if you may just address what he's wearing?
He's sitting at the defendant's table wearing a black T-shirt.
Your Honor, if the record could reflect that Mr. Moore has identified the defendant, Argus Harville.
The record will still reflect.
And Mr. Moore, can you tell us what you witnessed that day?
Me and a friend were standing in the yard. We came in from fishing when Mr. Harville's car came down the street at a high rate of speed. He pulled in the parking spot and stopped suddenly, jumped out of the car, went around to the passenger side where the victim was sitting and began throwing punches opened the door and began throwing punches into the car.
Okay.
And then
what happened after that?
Do what?
What happened after that?
Me and my buddy, we stepped inside my apartment. I called 911. He continued shortly there. for just a few seconds later, then stepped back and kicked into the car where the victim was sitting. Then he stepped away. She got out of the car, went around the front of the car, and attempted to open the driver's door, which he kicked shut on her. Then he drug her up towards the curb, and my buddy said that he threw her down, although I didn't witness that. But next thing I knew, she was sitting on the curb crying.
Did you see him strike her?
I couldn't see where his blows were landing from my point of view.
And you said the victim got out of the vehicle. Was she trying to get away from what you gathered?
I assume when she got out of the car that she intended to get in the driver's seat and leave, but
And sir, do you
Mr.
know-
Harville then left as soon as he escorted her up the driveway.
And do you know the defendant personally?
No, only in passing.
Do you know the victim personally?
We've met twice prior to this incident. She lived 2 doors down, but we hardly ever spoke.
Thank you. I have no further questions.
Cross?
Yes, Your Honor, before we give me a second, I want to pull up the videos from the incident. Mr. Walford, you testified that you didn't see him.
I'm Mr. Moore.
Oh, Mr. Moore, I'm sorry, I thought I heard Mr. Moore. You testified you didn't see where he physically connected the strikes to her,
No,
correct?
once I stepped inside and the reflection on the windshield, I could not see. It appeared that his blows were aimed at her head, chest area, but I couldn't actually see the impact.
Okay. Prior to that, what physical contact did you see between the two?
You've confused me here.
Prior to going to the house, what did you see as far as physical contact between them?
I just seen him get out of the car, began throwing extremely hard punches into the passenger seat where she was seated. Like I said, I could not see where the blows were landing.
Okay. And about how far away were you from where they were at?
50 feet, maybe?
Was there any sort of obstructions between you and where they were at?
No, other than the fact that the part you're referring to happened inside the car.
Okay. And I'm trying to remember, your parking lot is set up to where the cars pull in and the lights would shine into the apartments, correct?
Yeah, if a car pulled in the parking lot, yes, that's correct.
Okay. And your house or your apartment is on the far side, correct?
No, mine is in the middle on the south side.
Is Mr. Wofford's on that far side?
No, he lives in Navarre. He was just there. We returned from fishing.
Okay. Yours is, I'm looking at the video, that's why I want to pull it up. Is your residence 3?
Correct.
Okay. And that's not the last residence that's on that block?
No, there's number 4 is beside me.
Okay.
Up against the church property.
Okay. Now, where would they have pulled into the parking spot at?
It would have been in front of their apartment on the second parking spot. I believe her car was parked in there and he pulled up in front of it.
Okay. And do you remember what kind of car that was?
His car?
Yeah, the vehicle that they were in when they pulled
It
up.
was a Toyota dark blue of some type. I'm not sure of the model.
Was
An
it a
older one.
sedan or an SUV?
A sedan.
All right, so whose SUV was parked in that second
I
spot?
believe that was the victim's.
Okay, so they weren't in that vehicle?
No, they were not in the SUV.
Okay. So they would have been parked on the other side of the SUV then?
He pulled up in front of it. The parking spots are very long.
Okay. So he pulled perpendicular to where the SUV was at?
Yeah.
Okay. And you're in the third over from that area. Is there a boat or something like that in front of your residence?
Yes.
Okay. Were there any other vehicles that were parked in there that would have blocked or partially obstructed your view?
No, I had an unobstructed view. The only thing, she was in the car. Now, I could not see from the reflection of the sun exactly where the blows were striking or his kicks.
Okay. Do you know what was going on prior to that?
With them,
Yes.
I have no idea.
And you can see him, what you described as striking and kicking, but you can't tell where they were connecting or even if they were.
That's correct.
And then after she got out of the vehicle, what did you see?
She went around the front of the vehicle and attempted to open the driver's door, at which time he kicked it shut, and she took another step towards the back of the car, which is towards the street, and then he drug her up towards the curb, and that's where they went out of my sight. I was talking on the phone at the time.
So would that have been on your side of her SUV or on the opposite side of the SUV?
On the side I was closest to.
How did they disengage, or how did everything stop?
He got in the car and left.
And so he was the driver of the vehicle when it first came up?
Correct.
Okay. So, let me ask, after she gets out of the vehicle, he gets out of the driver's side car or driver's door and starts walking towards the apartment?
No, he got out of the driver's door, he walked immediately around the vehicle.
Okay.
And that's where the incident started taking place.
Okay, so that's
As soon as she got out of the car, attempted to get in the car, he kicked the door shut. He drug her up towards the curb. Then he walked back out, got in his car, and left.
Okay. And that's what I'm trying to figure out. So when he first, did you see him striking her or what looked like striking her while he was in the driver's seat?
No, I didn't see anything happen while he was in the driver's seat.
Okay, so then everything you would have seen would have been after he got out and went to the opposite side of the vehicle and opened the door then, correct?
Correct.
Which would have partially been obstructed based upon where the vehicle was parked and being on the opposite side of the vehicle, correct?
Yeah, I mean,
And you've already testified.
I already said that I couldn't see into the vehicle.
Okay. And you've already testified that you couldn't actually see him striking her either. You just thought it was based upon what you saw, right?
Based on what I saw, yes.
Okay. And at that point, she gets out of the vehicle and you said goes to the driver's side door where he kicks the door shut.
Mm-hmm.
Okay. You said escort her to the apartment. What does that mean?
He was actually dragging her, I'm a former police officer, and that's the term I would have used professionally.
By her hair, by her shoulders,
Had her
by her hand?
by her shoulders.
Okay. Demonstrate, like.
And like walking backwards, and she's struggling, and
okay.
They went out of my point of view then, and my friend that was with me, he was still looking out the window and said that he had thrown her to the floor.
So
Or to
there's
the curb, rather.
some sort of altercation. Sounds like he is, at this point, trying to force her out of the car, up to the house, and then gets in the car and leaves, right? Once he gets her to the house, he leaves, right?
They didn't go to the house. They went to the curb of the parking lot. After Mr. Harville left, she went in the house. She sat on the curb for just a little bit, and while I was talking on the phone and prior to the deputy's arrival, she went in the house.
Did you go out and check on her?
No.
You didn't go out and see if she had any physical injuries or anything like that?
I observed her from my window.
You didn't think to go out and check on her, though?
She was sitting there on the curb crying and look at her hands and talking on the phone.
No other questions, Your Honor?
Any redirect?
Very briefly. Mr. Moore, what was the victim's demeanor when you saw her after she got out of the vehicle?
Her demeanor?
Yes.
She looked angry, but I don't remember her yelling or anything like that. She just walked silently to the car door and attempted to open it.
And then you said she was crying after the defendant left?
Correct.
Okay. Thank you. I have no further questions.
May this witness be released?
Yes, Your Honor.
Thank you, sir. You're free to go.
Okay, thank you.
Next witness?
The state has no further witnesses, Your Honor.
All right, defense?
Yes, Your Honor. I would call Ms. Casey Matlock.
swear or affirm the testimony you're about to give will be the truth? If so, say I do. Thank you, ma'am. Just have a seat, and if you could say your name clearly into the microphone and spell your first name.
Kelsey Matlock, Kellcey.
All right, go ahead.
And Matlock smelled like the TV show, right?
Yeah, it's like the TV show.
All right. How do you know Mr. Harville?
He's my boyfriend.
And you are the alleged victim in this case, correct?
Based on everything that's going on, that's what I'm being considered.
Okay. And you're still pregnant, correct?
Correct.
Have you had some hardships since Mr. Harville's arrest for this case?
Financially, a lot. It's a lot of emotional stress that's going on. I'd like it to be resolved, but other than that, my health's good. Everything's good.
Okay. Did Mr. Harville provide support as far as financial concerns were with the pregnancy?
Yeah, before all of this stuff happened.
Okay.
And
How about support for the bills and things at your house?
yeah, bills, financially, we had an apartment together. Now, my income is very limited because I'm pregnant.
Has he been able, obviously because of the no contact orders, he hasn't been able to be part of the pregnancy yet?
No.
Can you remember what happened that day?
On May 31st,
Yes.
basically we were having a disagreement outside, and basically I went inside after the disagreement, but we were having an argument by our car, and then when I was walking inside, I tripped on my shoes, and then I was sitting there crying, and then he had left, and I went inside and got a shower, and then the police were banging on my door.
Okay. So you heard the testimony earlier of the witness.
Mhm.
At any point did Mr. Harville strike you or hit you with his fist?
No.
At any point did he kick you with his feet or anything like
No.
that? Can you tell the court what the altercation was about?
We were just having a discussion about communication and our relationship overall. Being pregnant's makes you a little have anxiety, so.
You heard the testimony that you had got out of the vehicle and walked to the driver's side vehicle. Do you remember doing that?
I had groceries in the back of our car, so I'm guessing that's what I was trying to grab was our groceries. I don't remember the slamming of doors.
Do you remember or recall Mr. Harville escorting you or dragging you?
No, because I physically would have marks if I was being dragged to the door, but I didn't have any marks on my body.
When the police arrived, did they tell you or ask you what happened?
Yes, they did.
And did you go to the hospital for any sort of treatments or anything
No.
like that? Did they call EMS or anything like that?
No.
Why do you want the court to modify the contact?
I want the court to modify the contact because I'm not in any harm or I feel safe in my relationship, and this is creating hardship in all aspects of my life, and because I'm pregnant, I want to be able to move forward and have a healthy relationship with the father in the picture. I don't feel like this is necessary.
What would you do if you did feel threatened if he was allowed to have contact with you?
Say again.
If he was allowed to have contact with you and you felt threatened, what would you do?
Reach out to someone, family, friends, or if it was a concern, then you obviously call the police.
No other questions, Your Honor.
Thank you. Ms. Giardino?
Just briefly. Hi, Ms. Mack.
Hello.
Are you aware that Mr. Harville was charged with domestic violence battery in September of 2024?
Yes.
You were the listed victim in that case, correct?
Yes.
Okay. And did you requested the state to dismiss those charges?
Yes.
Did the state dismiss those charges?
Yes.
Thank you. I have no further questions.
Anything further?
No, Your Honor.
May this witness leave the stand?
Yes, Your Honor, that Mr. Gates is okay with that.
Great.
Okay, thank you.
Go back to your seat. Thank you. You're free to go. All right. any further?
No, Your Honor.
All right, anything further from the state, other than argument?
No, Your Honor.
Okay. Mr. Gates?
Yes, Your Honor. Just so we're all clear, the defense isn't asking the charges to be dropped. I'm not asking that they be dismissed. I'm simply asking, pending the resolution of the case, Ms. Matlock and Mr. Harville be allowed to have contact. I know the state is probably going to reference a previous case, but those charges were dismissed. I would think if there was any issues, probably wouldn't have done that. Ms. Matlock did come in and testify. She's not afraid of Mr. Harville. She wants to have contact. She understands that if there's an issue, she can reach out and call 911 or call law enforcement. She testified there was no physical contact. It was an altercation that essentially ended and he left. I'd point out that the state's witness eventually stated that he actually did not see him physically contact her. He thought it looked like it, but he never saw him strike or hit her or kick her. He did say that, you know, escort turned to dragging to get her out of back to the house. But again, I don't know that that would rise to the level of battery. It sounds more along the lines of Mr. Harville's done with everything and wants her out so he can leave. I would also submit to the court, but for the fact that Ms. Matlock is pregnant, we wouldn't be here. This would be a simple battery case, it would be a misdemeanor, but because she is pregnant, now we're looking at a felony and we're looking at potential prison in this case. I think that given his lack of criminal history and the fact that Ms. Matlock's going to request to have contact with the court should allow for nonviolent contact between the two parties pending the resolution of the case. I don't see anything that jumps out that says this is a situation where we need to be concerned about the safety for Ms. Matlock or anyone else involved either.
Thank you. State?
Your Honor, the state is strongly opposed to modifying the no contact order. The state recognizes that the victim wishes to have contact with the defendant, and as for what she said, mainly for financial reasons. However, the defendant is charged with a serious offense. This is not a misdemeanor, and the victim is pregnant. The state is greatly concerned for her safety and the safety of the unborn child. The defendant was charged with domestic violence battery in 2024. The state understands those charges were dismissed, but that is solely because the victim was adamant that the state dismiss those charges. Your Honor, there's a clear pattern of domestic violence here. For that reason, the state requests that the no contact order remain in place. And lastly, the state would just like to address Mr. Moore's testimony when he stated escort. He is a former police officer, as he testified to, and he was using that in lieu of the word drag. But he did state that he saw Mr. Harville drag the victim. He saw the victim crying on the curb. That wouldn't be because she tripped over her shoelace. Thank you.
Thank you. Anything further?
Yeah, sure. I would just brief about that a bit. Say, he also said her demeanor was anger. I hesitant to go there, Your Honor, but Ms. Matlock is also pregnant and probably going through a lot and emotions up and down. I'm not going to say that all of this is because of that, but as I stated, I think what we have here is a chance for them to try and repair their relationship by allowing to have contact in the meantime. Again, I'm not asking the court to dismiss or drop the charges. I'm simply saying let them have contact, let them get back to where they need to be. We'll work the case through the system and see where we end up at. I don't see this as an escalation or a pattern of domestic violence. It isn't often, or it happens a lot, Your Honor, where people call law enforcement and nothing really happened. Charges get dropped all the time because they say, hey, look, it didn't happen. I don't want to pursue charges. We don't know what happened because the state hasn't presented that testimony evidence. They were dropped. She requested it. She's asked the same here. The state's not willing to do that, but I think at the same time, we could at the very least allow them to have contact pending that resolution, Your Honor.
Let me ask you a question.
Yes, Your Honor.
Well, I guess I'll ask it to both the state and the defense. When you say contact, what all does that encompass? Does that mean him moving back into the residence, or does that mean able to text only, or what? What are you seeking exactly?
Yeah,
Unlimited, unrestricted, nonviolent contact?
Yes, sure, that would be our request, no violent contact. You can have contact, you can live with you can do the normal things that they would be doing, it just can't escalate to a violence. If the court's not inclined to do that, then at the very least, Mr. Harville would like to at least have some way to contact her about the pregnancy, to be able to go to the hospital and be there for the checkups and the various things, and to be able to help provide support that he was providing prior to this issue.
All right, let me see what the state's position is.
Your Honor, the state maintains that we would request no contact. It's clear that if something does escalate between the victim and the defendant, the victim will not contact law enforcement. The reason we're here on this case is because there were 2 witnesses, and Mr. Moore contacted law enforcement regarding what he witnessed. So the state is extremely concerned. There is an unborn child involved here.
And I'd like to just rebut that one argument, Your Honor.
Okay, go ahead.
It was either that or nothing physically happened, and she chose not to call law enforcement because of what happened in the prior instance where, again, probably nothing happened and he got arrested.
Okay, thank you. So this is a tough one. Let me just put this out there. The witness, Mr. Moore, the court found his testimony to be entirely credible. And he said he didn't see the blows actually land on the victim or the kicks, but the court found his testimony to be 100% entirely credible in all aspects. No offense to Ms. Matlock, and I feel terrible for the position that Ms. Matlock is in. Ms. Matlock's testimony was not credible. I'm sorry, ma'am. It just wasn't. I think that the testimony that Mr. Moore gave was an accurate description of what he observed. And I understand the pressure financially that Ms. Matlock must be under. I understand how scary it must be to be expecting a child and then to be in this situation. And by situation, I don't mean just the case. I mean the whole issue of the events that led to this case happening. So there is a concern that the court has to weigh about if there's another altercation, that it's not just Ms. Matlock who is at risk, but she's visibly pregnant. She testified she's pregnant. I could observe she's pregnant. There's another life involved at risk. So I have to weigh that. On the other hand, I have a victim who clearly wants contact with Mr. Harville, and Mr. Harville appears to be the father of the child. At least that's what I gathered from Ms. Matlock's testimony. So, I have to think, well, this case isn't going to go on forever. And as soon as it's over, at some point they will, the court's not going to be here to supervise or enforce bond conditions, because there will be an end to this case. And those conditions wouldn't be in effect at some point. So what I'm trying to do is to find a way for some type of contact, for instance, support, financial support, because I understand that Mr. Harville, if he were to provide support, that might be a violation. I mean, it might be conceived to be contact, so that would be a violation of his bond conditions. So I need to modify the bond so that if he were to provide financial support, that would not be a violation. If they were to have electronic communication, as long as that's nonviolent and non-threatening, I could see a way for that to be acceptable. As far as him moving back into the home, or them having unfettered in-person contact, I have some grave concerns about it. The testimony of Mr. Moore was quite disturbing. And again, I found his testimony to be absolutely credible. So I'm asking the attorneys to help fashion some form of contact where Mr. Harville could provide financial support. They could have maybe telephone or text.
Your Honor, the parenting app can be used to facilitate communication between the defendant and the victim, and that way it's also has a record, or it's able to be seen. I think that's safe and fair.
All right. And I could see that Mr. Harville, if he wished to go to doctor's appointments or go to the hospital when the baby's born, if this case is still going on, as long as it's there and it's not some sort of going over to the victim's home. If they were at the doctor, at the hospital for medical treatment for the child, for the pregnancy, I think that could be permitted as well. So, yes, I will modify the bond conditions, but not in the full range of ways that the defendant is requesting. So I'm going to get Mr. Gates's input as well.
Yeah, I'm thinking, would there be a way to do kind of a supervised contact?
That's what I was thinking.
But I mean, I think obviously if the contact is at the hospital for appointments or doctor's offices, I think that would absolutely be supervised. I think the court could keep the no trespassing at the residence. I think that would be one way to ensure that he's not at the residence. I don't know much about the parenting app, so I can't speak to that.
I'm familiar with, it's like a texting app where all of the conversations are kept and cannot be modified or deleted in any way. So it's basically like texting, but I'm familiar with those from family law divisions.
Yes, Your Honor. I mean, if that's the only way to allow for contact, I think Mr. Harville would be in agreement on that provision. As I said, I think if we figure out a way through the app to help provide support, if that's part of the app as well, I think that would be appropriate, and allowing him to be there at the doctor appointments and stuff would be more than appropriate. I think he would at least appreciate being able to do that, and I don't think he'd have any objection right now to the no trespassing until we can get the case resolved either.
Okay, so here's what the court's going to do. I do not know if the parenting app, if you can make payments through it. I don't know that. So what I'm going to allow is.
Yeah, if I could, I think we have someone that might have an answer.
Ms. Oberleeson.
Yes, ma'am, I believe that you can. You can do video calls, telephone calls that can be recorded, and you can send payments and videos, text messages, and documents.
Fantastic. I knew about the documents and the videos, but I didn't know about payments, so thank you.
Now, we all know, Your Honor.
All right. So I'm going to allow non-violent, non-threatening electronic communication through a parenting app. And I'm going to let Ms. Matlock choose the app. Ma'am, there are several options. There's App Close. It's free, AppClose. It's an app. There's also Talking Parents, Our Family Wizard. There's a charge for some of the others. I know App Close is free, or it was when I was last in a family law division in 2024. So,
If Ms. Matlock will let the state know what app she chooses to let me know, then I will let Mr. Harville know so that we make sure we can coordinate that.
right. So if there is a way to do payments through that app, then he could make support payments to help.
Yes, ma'am.
If not, then I will allow like a Venmo or whatever cash app they could do.
Yes, ma'am.
So, but nonviolent electronic communication, that would include video calls through the app as well. So telephone calls, things like that. Mr. Harville can attend medical appointments and hospital visits, you know, or when the baby's born. Now, that doesn't mean go pick up Miss Matlock and take her back. They'd have to meet at the location. So, I will keep the no trespassing. I haven't pulled up the exact conditions. Is it don't go within 500 feet of the victim's home, vehicle, residence, things like
Yes,
that?
Your Honor.
That will remain in effect.
Yes, ma'am. Caveat being obviously vehicle if they're at the hospital
Well,
and happens to.
Yeah, knowingly, can't knowingly go within 500 feet of the vehicle. So then if they unknowingly park within 500 feet of each other, the court would not consider that a violation.
Yes, ma'am.
Your Honor, is the state able to inquire the location of the doctor's office that Ms. Matlock attends?
Sure.
Ms. Matlock, can you notify me what document you see or where it is? Pensacola, is it Ascension? Ascension Sacred Heart? Mm. I'm sorry? What's the name of the doctor?
I have like 3 doctors I need, so I haven't got to any of that.
Okay. You said it's a midwife? Midwife.
I'm filling out an order, but I do want to ask Mr. Harville, sir, do you understand the court's ruling and do you have questions about it?
I understand.
Okay. Any questions?
Not at the moment.
Okay, well, if you think of one sitting there, now's the time to ask.
If he does afterwards, Your Honor, I'll try my best to answer. Otherwise, I can address the court and state with those questions.
Okay. I'm filling out an order. Ms. Giardina, do you want Ms. Matlock to notify the state or pretrial services of the app she chose?
I believe both.
Okay.
If that's okay.
Yes. I'm going to ask the attorneys to approach and read what I've got on this order and see if it's acceptable or do I need to clarify anything.
Man, I got this. Let's roll.
Fight fire with fire, take one.
Have you been injured in an accident and need righteous representation? Call us. Because we fight fire. Damn thing ain't working. Whoa!
Not cool, bro. I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations.